All right, this time this court does call case number 127422 in the matter of the marriage of Marnie, Leigh, Gracey versus Mohammed Albawardi, and I'm sure I mispronounced that. Can I have appearances from the parties just real quick and give your name and bar number so we have that set? Those who are arguing.
Your Honor, Jeffrey Little appearing on behalf of the appellant Marwan Albawardi, Kansas Court number 21903. Also appearing pro at each is Mr. Ezra Young, who will present argument on behalf of Mr. Albawardi.
And he will be arguing?
Yes, ma'am.
Okay. All right, and then for the appellee?
Your Honor, Justin Phelps, bar number 22670, and Richard Semeniego, 22947, and I'll be handling those.
All right, thank you.
Ms. Gracey is also the person present.
Right, I see that. All right. Mr. Young, I'm going to help you out. Did you want any rebuttal time?
Yes, I do, Your Honor. 3 minutes, please.
All right, 3 minutes is granted. All right, and you may proceed.
Thank you, Your Honors, and may it please the court. I'm hoping my argument here will be short, not because, like previous counsel, I didn't have opportunity to prepare. I did have plenty of opportunity, but I think as a matter of Kansas law, this particular case, though the facts are obviously idiosyncratic and somewhat unique, is fairly easily decided under well-established Kansas law. We are appealing a divorce judgment below where Ms. Gracey contended and was credited by the trial court on, say, a very unusual theory of marriage, that after having married Mr. Albawardi once in 1998, having divorced him twice, not once but twice in 2008, and having been found to not be credible about alleging both a Colorado common law marriage in 2008 as well as a Dubai common law marriage, that somehow, fast forward to 2016, a Kansas common law marriage sprang into existence, a marriage she never pled.
And she would take issue with the word sprang, is that correct?
I believe she takes issue with anything her ex-husband says, yes.
All right.
And I would call it springing in the sense that I understand and respect as a visitor to Kansas that Kansas recognizes common law marriage. That's obviously a minority position, but for very good reasons.
But it's a controlling position.
It is, and if I can finish, Your Honor, for good reasons.
Wait. He did make that point, so I just want to make sure we heard that. Go ahead, you may proceed.
Yes, Your Honor. So yes, it is Kansas law, but a requirement of common law marriage in Kansas is there must be a present marriage agreement. It can't just be outside observations or suppositions of third parties. It can't just be one purported party to the marriage believes that there's an agreement secretly in their mind. It can't be that someone simply believes their initial marriage never ended when it was ended by divorce, again, here twice, prior to coming to Kansas. And it most certainly can't be, I think, simply a vehicle to relitigate, as Ms. Gracey herself testified below, divorces that she felt 12 years after the fact were not fair to her, that she never challenged in the jurisdictions in which they were issued.
So by taking on the issue of agreement, are you conceding the other two elements of common law that we recognize here in Kansas, which is the capacity to marry as well as holding yourself out as husband and wife?
I appreciate you drawing attention to that, Judge Pickering. So there is a capacity problem here in the sequencing of what Ms. Gracey alleged in this sense. A common law Kansas marriage was not pled and argued until around April 2022. By that moment, or by that time, Mr. Albawardi had already married another woman in Monaco. That marriage was never challenged in Monaco. Ms. Gracey was apprised of it.
Is the marriage in the record? What is the date of the Monaco marriage?
I believe it is February 12th or 20th, 2022. It should appear in record volume 42. And it also
just
appears.
Testimony, or is there?
No, there are actual documents. That's what volume 42 is, Your Honor.
Was that added after arguments? The marriage certificate added after the district court made its ruling?
I believe that there is a motion for reconsideration, at which point the actual documents were put into the record through that mechanism. There was an effort to introduce that evidence at the trial, and it was denied for purely evidentiary reasons that we're not going to
And
get
when did
into.
litigation in this case begin?
February 2020 is when this divorce suit was filed by Ms. Gracey.
So the divorce suit begins in February 2020, and 2 years later, your client marries. Is that correct?
Yes, but let me be clear here on this record. The allegations in the divorce suit as filed in 2020 as maintained up through April of 2022 were the 1998 marriage never ended, or there was a secret religious marriage in Dubai in 2008. There was no Kansas common law marriage alleged.
So then what you're arguing is, the way pled, the argument is actually that there was a continuing marriage from either 1998 or 2008.
Yes, Your Honor.
And so then if the marriage was proper under the jurisdiction of which it occurred, we would give that marriage full faith and credit here in Kansas.
Yes, Your Honor.
And does Colorado not have common law marriage?
Colorado does have common law marriage, but Ms. Gracey abandoned that theory before trial and switched it to, at least in papers, not her testimony, but at least in papers, that it was a Kansas common law marriage. And as to the Colorado common law marriage as pled, Ms. Gracey insisted that the Colorado common law marriage was somehow entered into before she was divorced in Colorado.
And so it is your contention then that the marriage, the common law marriage in Kansas would have to be established as of Kansas residency?
Yes, Your Honor.
Okay.
And just to be clear on this record, there's no alleged date of or approximate date of such common law marriage. None was testified to. Ms. Gracey concedes in her brief, and I believe that's a fatal admission, that at page 38, that she is alleging that there was no requirement for a new marriage agreement to be brokered or exchanged.
So let me ask you this. Given the public policy of recognizing marriage and thinking marriage is good and important, would an invalid common law marriage that then is moved to Kansas but satisfies the Kansas common law statute become a valid marriage?
Potentially, Your Honor, but that is not what is alleged in this case. Ms.
Okay.
Gracey alleges, and Judge Pittman below held, that it was only a Kansas common law marriage that was entered into. And he was very clear in this respect. Judge Pittman held that Ms. Gracey was not credible as to her claim about the fraudulent two former divorces, let alone the Dubai 2008 secret marriage. This is a situation in which someone is, and I understand pleading standards are usually flexible, but this is a situation where I think, Judge Pickering, this is much like the CVR case, where someone has kind of pled themselves into a box where they plead too much. And here in this case, Ms. Gracey is sensibly saying that her 1998 marriage never ended, despite findings below that she has not appealed on cross-appeal, that those divorces are valid and must be honored in Kansas.
Did you have an argument regarding the burden of proof that was required here?
Yes, Your Honor. So we believe that the burden of proof is heightened here on Ms. Gracey because there was, by the time of the jurisdictional trial, it was alleged, argued, and later proved, both by testimony as well as documentary evidence that has never been challenged, that Mr. Albawardi had subsequently married another. So to that extent, Kansas policy with respect to marriage is we presume that the last in time marriage is valid, and part of what is built into that presumption is the assumption that a prior alleged common law marriage terminated at some point.
Now, I mean, you say it was put into evidence, but we have clear indication from the district court that they did not find your client's testimony credible. And so there is nothing other than his testimony during the trial indicating that he remarried.
Well, there's additional evidence, and we cite to it in our opening brief, Your Honor. He testified about wearing a wedding ring. He testified about, the name of his wife.
Right, I'm saying other than his testimony.
In addition, during the trial, the jurisdictional trial itself, There were exhibits, I believe this is part of record volume 38 that he introduced. This is the paperwork he had to file in Monaco to be married in Monaco to Emily Albawardi.
And that was introduced during the trial.
Yes, and it was exchanged in discovery as well.
I want to go back to the beginning. We kind of took you off, which is common here, from agreement to other issues. But would you agree that a court could find agreement to be held as a married couple through the statements of one and the actions of the other? In other words, we're not looking for a piece of paper that says, I agree to be held as your spouse, right? But we can, by the statements of one of the spouses and the actions of the second spouse and how those close to them perceive them, that there is an agreement. Would you agree with that, since we never will have a piece of paper?
I would not, Your Honor, in this situation. The only situation in which Kansas courts have taken that position is where one of the supposed spouses is deceased, so they are unable to testify about their agreement, and that makes sense. This is a situation where both alleged spouses were alive, and though Kansas law doesn't require, as Your Honor pointed out, a piece of paper or specific magic words that must be uttered in a specific way to establish marriage, there must be some sort of present marriage agreement that is reduced to words in some form. Here, Ms. Gracey herself admits there was no such agreement brokered in words by both parties in Kansas. If I could, yes, Your Honor.
Were those words brokered by the parties in Colorado?
No, Your Honor, and Ms. Gracey also did not. Again, she abandoned that theory. And the other problem would be this, Your Honor, if I just may point out. She alleged that this alleged common law marriage initially in Colorado in 2008 was brokered prior to being divorced from Mr. Albawardi. So that would be a marriage on top of a marriage situation, not a new common law marriage that is taking place after a divorce.
Well, but that would also be decided under Colorado law, which was not done here. So let me ask you this, why wouldn't this just be a remand for failure to consider this under the proper law?
Well, because again, Your Honor, actually it was decided below. There were Colorado law experts. That should again be in volume 38, the trial record, competing experts on both sides. That argued about that, and I would also say, again, that sort of pushes the limits of what Kansas's proper jurisdiction is. Again, the minority position of Kansas, which is the law in Kansas, cannot be imposed outside of Kansas's borders.
No. I mean, if you're common law married in Colorado and you move to Kansas and we recognize common law marriage, then you're common law married in Kansas if you also meet our common law marriage guidelines. And then you divorce in Kansas, right? So we would have to determine if you were common law married in Colorado.
No, Your Honor, because the Monaco divorce was finalized in early 2009, and we point to that in our brief. So if there were a Colorado common law marriage in 2008, it would have been terminated by the Monaco divorce. And if I just may gently point out...
Don't worry about that. You can ignore the clock for a moment. I would like for you to be able to summarize and make your point.
Okay, yes, Your Honor. Again, I think, and I feel for the parties on a kid of divorce. Divorce is messy. This is messy for families. I get that. This is a situation where one of the alleged spouse's story constantly changes. She has been found not credible by the trial judge below. And the trial judge kind of attempted to do, I think, what Your Honors are trying to do. You're trying to do justice by the parties, but you're trying to come up in part with arguments she either abandoned or never put on evidence for. Again and again in Ms. Gracey's testimony, she insists, continuously married since 1998. If anything, the prior divorces were frauds, which the court below did not agree with, and Ms. Gracey did not appeal. If she wants to insist, and this is remanded, that a Colorado 2008 common law marriage occurred, well, that would have been terminated by the last divorce in time, which would have been the Monaco divorce, which finalized in 2009.
I want you to know that our questions are not intended to give the impression that we are trying to do anything other than apply the law. So I want you to know that your statement was a little bit offensive in that regard.
I apologize
Okay?
in that respect.
Because the common law marriage, the public policy of the state of Kansas and the state of Colorado is to recognize marriage where one exists. Therefore, where we have a lot of indicia of marriage, I mean, you say, you know, she changed her mind, this and that and the other. There is a decent amount of indicia of an ongoing relationship, inconsistent with divorce. I'm divorced. I'm aware of how divorce works. Inconsistent. So we're trying to see where the law meets under these bizarre facts. We're not trying to make it fair for anyone, etc. Okay?
I appreciate Your Honor, and again, I apologize, I did not mean to overspeak. I would only add one more point to that.
Yeah.
And this is something we make in our opening brief as well as in our reply brief. The supposed indicia of marriage that Judge Pittman relied upon below, most of those indicia are indicia of a co-parenting relationship.
I do understand that, and I do agree. I do see a very generous co-parenting relationship, which is lovely, and we don't want to discourage. So thank you for
Your
that.
Honors.
Thank you. You will be granted your 3 minutes of rebuttal.
May it please the court. You hear often in this line of work that there's two sides to every story. And I think that saying often infers that maybe there's some validity to both sides. But I would proffer that there are not two sides to this story. There's not a simple difference in perspective of a mutually agreed upon event. Marwan Albawardi's jurisdictional challenges in this matter are premised on an alternate and false reality, one that was outright rejected by the trial court as lacking credibility. Marwan has engaged in psychological warfare against Marnie Gracey for nearly 8 years, denying the very existence of their 2 decades of loving marriage, which bore 3 beautiful children.
Counsel, we are not a jury trial.
I know.
I just want to pause because I want to make sure everybody knows this is an appellate court. We are a court that reviews errors, and so we're not a jury. And so I appreciate the passion, but let's get down to the 3 facets of what makes a common law marriage. Why don't we start there?
Sure, Your Honor.
And I appreciate what you're saying, but actually before we get to that, you talked about credibility. Who did the district court judge find credible in this case? Why don't we start there, and then we'll walk you through. You can walk us through the 3 elements of common law marriage.
You bet, Your Honor. I apologize. I had more time than Mr. Howell to prepare. So,
Yes.
What I would say on credibility, the district court judge made abundantly clear that he found Marnie Gracey, Dr. Roger Gracey, her father, to be more credible than Marwan Albawardi as it came to the parties' relationship, to the marriage, to the holding out. I think the findings of the court in regard to all of the other witnesses that Marnie called from the Cheney community or the co-workers, her co-worker from Dubai, Rebecca Ortiel, also indicate that the judge found them credible. I think the only aspect where the judge had any question about the credibility of our presentation of the evidence was in regard to the findings of the 2008 divorces. And essentially what Judge Pittman found in that regard was the testimony of Marwan's friend Brian Delka, he found to be credible. This was a friend in Colorado that testified that Marwan was there in 2007 and 2008 timeframe.
Can I ask you this?
Sure.
I'm having some trouble with particularly after divorce, with the intent to remarry. So when do you say that the intent to remarry occurred?
So what I would disagree with is that there has to be a specific intent to remarry, like that there's some type of actual separation. And I think the reason this case is unique is because of the circumstances of those divorces.
Because they were
paper
fraud?
Divorces. Well, because they weren't legitimate. I mean, neither
Right.
party actually intended them to be.
They filed divorce papers with the court, so you're telling me that your client committed fraud?
No, I'm telling you that my client believed that she was converting a U.S. marriage to an Islamic marriage. And she testified that she went through an Islamic marriage ceremony. Now, Judge Pittman did not say that did not happen. What he said was that they did not fulfill all of the requirements in order to make it a valid marriage in Dubai, the Islamic marriage. So what my client testified to, and I believe the court found, was that there was never any actual separation. That as the parties believed and lived, that they continued to live as a married couple, that they had that present agreement, that present consent continuously. And that's evidenced in not just my client's testimony, but in multiple points in time throughout their life. So even that, in the context of that 2008 divorce,
So then the court found there was not a valid divorce, and so therefore we're actually divorcing under the marriage?
no, the court said that he was not going to invalidate the 2008 divorces. And now we didn't cross appeal that, but you try to reconcile how you can divorce twice from the same marriage. But that's what Marwan Albawardi proposed, and my client acquiesced in. And we shouldn't expect individuals to necessarily understand all the nuances of the law, and I think that's where common law marriage comes into play. You see this in some of the cases that we cited in our brief, like the Travers case, that these individuals don't always do it right, but that there can still be a recognition in common law marriage that they are married. And so when he invalidated, when he validated, the trial court validated the 2008 divorces, it left him with, he had to assess what was left. And what he decided was, because the parties continue to live with that present mutual consent to be married and to hold each other out as husband and wife, that when they relocated to Kansas in September of 2015, which recognizes common law marriage, that they were then remarried at that point in time.
So I think this is an interesting theory, because I do believe there is United States Supreme Court precedent regarding a divorce necessitating a intent to remarry. And so what you're asking is to say, actually we should ignore the law and the divorce and just find that they were never divorced, or that they intended to common law remarry at that point, which
I'm not sure which case you're referring to. It's not a case that I've seen in the brief.
it's from the 70s. But it's
Yeah,
fine.
there is, what I'm saying is that the intent is to be married. The intent is to be married, that's the requirement. And that was
After a divorce,
in
I
place.
believe there needs to be an intent to remarry.
Right, and you could call it remarriage or you could call it be married. There's an intent after the divorce to continue to be married. So
And so the evidence is that they continue to have a relationship.
that they continue to have a marriage and hold each other out as husband and wife.
There is evidence that a husband did not refute being called husband. The intent to be married is undercut by the divorce.
So I think what the court is proposing is a reweighing of the evidence. That's why I don't think that's a legal argument. I think that
No,
that
there's
is
law that says once you're divorced, you must remarry. That is law.
I think the law says that you have to have I think you're adding a condition into the requirements of common law marriage. Common law marriage requires a present intent to be married, and they had that when they relocated to Kansas in September of 2015.
You said, I want to follow up on that. So you said September 2015, then they're remarried. So by moving, let's say they moved from Missouri, hypothetically, I'll give you a hypothetical. Missouri does not recognize common law marriage. They moved from St. Louis, Missouri out to Kansas, beautiful small town Kansas. So back in 2014, they would have not been married, but because they moved to Kansas, now they have a common law marriage. Is that correct?
I think that's consistent with what the district court found, yes. That if all the elements exist and the only lack of legal requirement is that they're residing or domiciled in a jurisdiction that recognizes common law marriage, then once they take residence in a jurisdiction that recognizes common law marriage, because all the other elements are in place, then it is recognized. And that is consistent with the Travers, Sullivan, and Marnie cases that we cite in our brief. Travers is a U.S. Supreme Court case. Sullivan, I believe, is Pennsylvania, and Marnie is a Montana case. But when we look at the Gillespie and Conley cases, which are Kansas cases, those talk about the capacity and when there's a legal incapacity. So someone gets divorced and they get back together again, but there's a 6-month requirement where they cannot be remarried. If they fulfill the mutual consent to be married and hold themselves out to the public as being married within that 6-month time frame, even though they don't have the capacity to marry, the court has found in Kansas that as soon as that legal incapacity is lifted, that they're common law married. They don't have to reaffirm or then start holding themselves out. And so yes, when you move back to Kansas, if all of those other requirements are in place, but you were residing in Dubai and did not have common law marriage, then when you come to Kansas, it would be recognized.
Okay, so let me ask you this. Then when you come to Kansas, does there need to be a present intent to be married?
There needs to be in existence a present intent to be married, yes.
Okay, so they came to Kansas in 2015, 2016. What is the evidence of husband's present intent to be married in 2015?
Well, I think it's circumstantial because it was already a lifestyle that they were living. So it wasn't like they got here and then had an event where they reaffirmed. But I think the best piece of evidence that the court relied on was an email from June 5th of 2017 Marwan sent to a school in Illinois. They were seeking to apply for their daughter. And this is the one sentence Marwan wrote in that email. We moved the family back to my wife's parents' hometown, that's Cheney, from Dubai for some extra help and quality time during my wife's pregnancy and my boy's first year. So this is during the period of time after they have relocated back to Kansas, in his own words, affirming that she is his wife and that they moved back to Cheney. And that's both of the issues that this court has in front of it. And to be clear, I promised in my opening, even though it may have been impassioned, that I was going to get to the standard of review. But the standard of review here is obvious. It's a substantial competent evidence standard. And that's it. It's a substantial competent evidence standard. And so we can sit here and we can talk about all of the conflicts in the evidence. I think that's a fruitless exercise. I think the question really is whether Judge Pittman did he commit clear error on the findings of fact that he had? Well,
with the findings of fact, though, you have to also establish that they meet the law.
Correct. That's still within the substantial competent evidence analysis. And so, again, you're looking for clear error in the application of those facts to the law. So we shouldn't be reweighing that evidence. If there is evidence to support
No reweighing.
Right.
I mean, we say, yes, that evidence is there, and yes, it says that, and that exists. That evidence doesn't meet the legal standard. That would be what would be decided.
In all of the appellate cases that have been cited involving common law marriage in the briefing in this case, there are conflicts in all of them. And the question is whether the trial court had substantial competent evidence based on what it was presented. And when you have 26 members of family, friends, in the community coming in and validating the marriage, and you have Marnie Gracey herself validating the existence of the marriage, and you have a credibility determination by the court that she is credible and her witnesses in that regard are credible, this court should not take that lightly, and it should not be tempted to rock the boat on that just because there is some conflict in the evidence, and because Marwan Albawardi decided that he wanted to be done with his family.
Counsel, I think you're confusing our questions with an intent, and there's no intent here.
I want to make sure there's not, that's all.
I've never been in an argument where a court was thought to be rocking the boat. This is oral argument. we have questions. We're not rocking the boat. We're looking at a very unique case which demands questions.
Well, it appears to me that the witnesses from Cheney were addressing the concept of holding themselves out as husbands and wife. But that doesn't address the agreement between her and him to be married.
There is a distinction between those two, but courts have also found in what we've briefed that the holding itself out can be circumstantial evidence of the present mutual consent to be married.
Oh, I don't disagree with that, but I'm just saying, there are three parts to this process.
Yeah, and what I would tell you is, we briefed at length the findings of the trial court, not just the email I referenced, but the testimony of Marnie Gracey about the Islamic marriage, about the fact that they did enter into IVF in order to have children, and that required a marriage certificate, that the trust agreement referred to her as his wife, that in 2014 they were in Ireland testifying in a court proceeding there and referred to each other as husband and wife, both to their counsel and in testimony. I mean, there is abundant evidence, even before they moved back to Kansas, that they continued to hold themselves out and to each other even, to have that mutual consent to be man and wife. I would like to provide a couple closing thoughts if I could, Your Honors.
So have you finished all your arguments as to why you believe that there was agreement that Mr. Albawardi showed his agreement to be married? Have you presented all your arguments here?
I don't have anything further to add on
Okay,
those
I
points.
just wanna
Unless
make
the
sure.
courts have further questions.
Okay.
I think that was well briefed.
Okay.
There are just two quick points I'd like to make if the courts would allow me. And I pray this court recognizes and certainly don't imply any actions otherwise, but that the court recognizes the simplicity of the legal issues and straightforward justification for affirming the trial court. This is a unique case, and it certainly can appear complex based on the fact pattern, but it's not complex. These are simple and straightforward issues. It is a substantial competent evidence review. And the last thing I would say, and again, this is no negative comment about the Court of Appeals, it's just a statement of fact, but this case was filed in 2020. It took more than 2 years to get a jurisdictional determination. It took about a year and a half after that to get a final judgment, in part due to obstruction of discovery efforts. It's been on appeal for about a year and a half. We're asking the court to affirm and affirm expediently because there is child support wrapped up in this. There are assets throughout the world. He has not posted a supersedes bond, and everywhere we try to go to collect on the existing judgment, the argument that we hear is that it's on appeal, it's not final. Well, we disagree with that argument, but we would just as soon be done with it, and so we're just asking. I know the court is going to be diligent on this, but we're just asking for expedience because child support is involved. Thank you.
So there's not child support being paid for the children? No funds are being given
There's not
for the
been
children?
any financial support provided since September of 2020.
Okay. Thank you. I appreciate that. All right. Thank you. We have a rebuttal then.
Thank you, Your Honors. If I can adjust the child support representation first. Child support was paid up through 2022, at which point, on advice of counsel, Mr. Albawardi, to avoid acquiescing to jurisdiction, stopped child support. That does not mean, however, that he, more importantly, because it's his mother, Ms. Al-Jamaz, who actually has the money in this family, have repeatedly offered, and I have repeatedly offered to Mr. Phelps, and this appears in some of our motion practice before this court, to immediately pay Ms. Gracey child support with some stipulation that this is not an acquiescence to jurisdiction in Kansas. They have repeatedly refused, but that offer remains to this day on the table. I spoke with Ms. Al-Jamaz yesterday. She told me that she would be proud and would love to support her grandchildren. So that is not an issue. She is not vindictive. She loves her grandchildren. She believes her son made a mistake. I happen to agree with her here. But she wants these children to be supported and to be loved. In addition to the money, which she believes they're entitled to, she wants to get to know them, and she wants them to get to know her in the
Okay.
Middle East.
That's
Yeah,
fine.
but that's not a point here. She could be if she's the one that holds the purse, as you're saying, she could be making payments to the benefit of the children outside the decree. She's not subject to the jurisdiction of this court.
She has tried and offered, Your Honor, repeatedly. Ms. Gracey will not accept it unless repeatedly we paid it through the Kansas Child Support Center. I might be goofing
Well,
up the
if
name.
it doesn't go through the child support center, it doesn't get credited.
And I understand, Your Honor, we have offered to cut a check. They refuse to take it. I can't force them to take a check.
You can put it in the United States mail and deliver it and see what happens. She can, not you.
Yes, Your Honor, I
If
suppose.
it's a gift from grandmother to the grandkids to provide for their support, it is outside this divorce.
Ms. Gracey has represented that if they receive payment, they will take that as acquiescence to jurisdiction of Kansas over this divorce case.
Despite it being a grandmother?
Yes, Your Honor. The Chancellor of Delaware tried to broker such an agreement because she also understood this. She was willing to do it and willing to monitor it. Ms. Gracey
Well,
declined it.
that's really outside the issues here.
I know, I'm just, because
Uh,
Mr. Phelps brought it up, I think that's important. The only other thing I wanted to point out is, Your Honors, you brought up the Supreme Court case on the requirement that there be a new agreement to remarry.
I
Right.
saw you nodding your head back.
Did I-
Yeah, so it's-
Did I misstate it?
No, so it's a Kansas Supreme Court case. It's in re estate of, I'm probably going to butcher this name, Keeming,
Meaning,
215 Kansas 869. Your Honor was correct. It was 1974. So great memory there. The only other point I just want to make real briefly, Your Honors, is Mr. Phelps is sort of playing wishy-washy with the requirements of a common law marriage here. Divorce, a prior divorce, isn't an incapacity to remarry. Most of the incapacity cases they deal with, minors, they're not old enough, or in a specific state where there's some sort of holdover, where there's some sort of block on one of the people, usually because diminished capacity, something like that.
Right.
Being previously divorced is not an incapacity to marriage in Kansas, but there does need to be an in re estate of Keeming is crystal clear on this, and the Kansas Supreme Court has never held any otherwise in the entire history of the state of Kansas that if parties divorce, you can't just say, roughly from the quote from In Estate King, there was no divorce. We were always married. That's not good enough. There needs to be a new brokered agreement to marry. The only other thing I'll point out is in Mr. Albawardi's opening brief at page 6, we cite through copious evidence provided at the trial of him holding himself as divorced to multiple governments throughout the world, as well as the state of Kansas. I believe it was the Revenue Department, representing that Mr. Albawardi has never been a resident of Kansas.
What was that? You were referring to page 6?
Page 6 of Mr. Albawardi's opening brief,
Okay.
and it cites here because I realized there are 42 volumes. It's a long appendix. So I just wanted to point out that that is where you can find all of that
Excellent.
paperwork, Your
Excellent.
Honors. And
And I
thank you again for.
appreciate-
So,
Appreciate
so
your- go ahead.
this appeal is all about the jurisdiction of the court. You haven't appealed anything about the final divorce decree and the division of assets that were contained in it?
We do not believe that we have the ability to do that because Mr. Albawardi defaulted. I believe Mr. Phelps already sort of alluded to Ms. Gracey has attempted to enforce this judgment in other jurisdictions. That was not an issue as per those courts. So far, Illinois, as well as Delaware Chancery and the Delaware Supreme Court, they didn't rule against her there in final judgments because this was on appeal. They said that this is unenforceable for reasons under their own law. And Ms. Gracey does not want to listen to those judgments. I don't know what to tell you.
Thank you.
Thank you, Your Honors.
Thank you. All right, we will take this matter under advisement.